suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
That real good lawyer has set foot in the building, and we're awfully glad that he has. David Whiting, good morning and welcome back.
Thanks, Virginia.
I know you didn't really go away, but, you know, to your 3D
I did
form.
go away, yep.
That's right. No homework.
No homework. No. Just see what you can do on holidays. Take on no jobs. But there's a couple of fascinating cases that I've found, and we all think America's a bit crazy. In Germany, there was a female nurse who was convicted of killing 4 aged care patients during her time at a particular job, and they terminated her employment. So she sued for wrongful dismissal.
No.
You will be pleased to know she was unsuccessful.
Was she unsuccessful and jailed?
15 years she got, but and then said that she was bullied and her termination was unfair and unjust. And fortunately, the employment tribunal she went to in Germany didn't agree with her, and there was no compensation ordered.
If it wasn't so awful, it would be funny, but it is awful.
I just think how brave was the lawyer who took on the job of making the claim.
When you reached for the word, were you trying to say stupid rather than brave there?
Yeah, foolhardy. Perhaps
that's the one,
you know, it's like when they say with the greatest respect.
With the greatest respect, meaning you're an idiot.
None.
Yes, that's right.
And then there was a case that's just been finalised in the highest court in Italy over the noise coming from a toilet in an apartment. It's taken 19 years to resolve.
Don't start that with me. I made one of the greatest faux pas of my life was when I went and stayed with relatives down in Calabria in Italy, and they lived in an apartment building, and I got up in the middle of the night and I went to the toilet and I went back to bed, and boy did I get it the next morning, because you don't flush of a night time, because the noise is such in a lot of those Italian apartment buildings where it will go through the pipes and wake up every single household in the building.
Okay, well,
which apparently I did, and I didn't know that. So I did the right thing. I mean, it's not so outrageous just to flush a dunny, is it? Oh boy, I got what for.
Okay, well, in
Calabrian dialect.
Oh, I bet. So is that when you moved?
No, that's when I just behaved myself.
Okay.
And I just went back to the old chamber pot principle of we'll sort that out in the morning.
Good.
Yes, okay. Enough of all that. That took an interesting turn that we didn't expect. 1300 222 774. David Whiting standing by to help you out. Greg in Frankston, how can we help?
Oh, good morning, Virginia. Good morning, David. Fascinating story for you.
Well, keep it tight.
Okay. I've lived in my house for 32 years. I have a neighbour at the end of the court that I live in, and he started building his house, I think, 27 or 28 years ago. We believe he's had no less than 42 building permit extensions from the council, and we, for the life of us, myself and our other residents here, have had no joy with the council in trying to get this person to complete the building. It's not even at lock-up stage.
What are you trying to achieve?
Yeah.
Well, I don't want to die before this thing isn't finished.
But it's not your house.
No, it's not my house, but it affects the values of the area, and it affects the aesthetic look of the neighbourhood. It's become a laughing stock and a joke. And my understanding is that if I applied to build a house today, I don't think any council would give me 28 years to even get to the stage where that this person is.
Probably not, but if he's got a permit that was 28 years old, he's probably operating on the rules as they existed 28 years ago and not now. The expectation is that if you get a building permit, you'll start the work within a particular time frame and finish it within a time frame. Why would you not, if you're concerned that the extensions are unwarranted, unreasonable, have a talk to the Ombudsman's office on the basis that that the council's not playing fair?
Yeah, you could do that, but not. It's unusual for a council to extend it that many times. I'm aware of councils that will allow you to extend a permit that's been granted once, maybe twice, but then not again, David.
It depends on whether we're talking about a planning permit or a building permit, and it may well be that some permits have lapsed and new permits have been applied for.
Right.
And I suppose the alternative is then we make him pull it down. If we don't give him another permit, then the answer is have to pull it down, and that may be unreasonably harsh. But if you think that the council is acting unreasonably and you can't get a proper answer from the council, complain to the Victorian State Ombudsman.
Okay. I think that's in the process at the moment, yeah.
Good.
Okay.
Right. Well, good luck with it, Greg. Let us know how it goes. Thanks so much. Peter in Coburg, good morning.
G'day. Thanks for taking my call. So just have a question. So my wife and I separated, I suppose, about 18 months ago. She's in a rental property and I am in the family home, which we both are on the mortgage for. I pay all the mortgage on the house. My question is, can she come to the house without notice?
In the absence of an order, she has... I take it that the house is in both names?
Correct, yes.
In the absence of any kind of order or agreement, she has the same rights of access to the house as you do.
Okay. Okay, perfect. Okay.
Now you might strike a deal with her as to when she might and might not come. Presumably she's paying her rent and you're paying the mortgage.
That's correct, yes.
So you might have a discussion with her about each of you having the right to occupy the property in return for the payment of the mortgage. But
Okay, cool.
absent an agreement, she has the same right to walk in the front door as you do.
Okay, thank you very much. Really appreciate it.
Okay, good luck with sorting that one out. Andrea, in Blackburn, go ahead.
Oh, good morning, Virginia and David. Thanks for taking my call. I listen all the time and I've never had to ring before, so bear with me. Last week, my NBN bracket was ripped from my property, splintering my fascia board and leaving it dangling in midair.
Yes.
This was done by the garbage truck. I rang the council and they advised me that the NBN cable was too low and to claim on insurance. Now, I've done some research and I've established that the minimum allowable height of an NBN cable is 3.5 metres over a road and a private driveway, which this was, and the combined height of a garbage truck and a 120-litre bin being emptied is a minimum of 3.8 metres. Therefore, it was only really a matter of time before the two collided.
Yes.
So, David, I would like to claim the excess that I've got to pay my insurance company to repair
the problem you've got, Andrew, is that you can't split the two. You're suffering loss and damage for the reinstatement of the NBN box, and you're coming along and saying to your insurance company, I'll give you $400 or whatever the figure is, and you get it fixed. And you then want someone else to pay the $400. No. What you might find is that the insurance company, you make the claim, the insurance company takes whatever it is that the insurance company wants and fixes the problem, and then might go to council and say, you now owe me. The excess is really a claims handling fee and is designed to discourage people making little claims.
Oh, sure. Yeah, I know. I'm prepared to pay the excess, but that was my next step. What do? I go to the council, and I say, right.
No, you do one of two things. You go to the council and say, it's your fault. It was lawful what was there. The answer is, it's up to you to manage within those regulations, or you make a claim with your insurance company. One or the other. You can't have both.
Okay.
Right, okay. Okay, but then I've also got a 14-day defect notice on my fascia board from the power company. So if it's not fixed by Friday week, they're going to cut the power off.
Then make the claim with the insurance company and get things moving.
So make an urgent claim. And they should move quickly on that, shouldn't they?
Yeah, they should. And really, she just wants to make sure that the NBN cable is at least 3.8 metres above ground level. Now,
a caller saying about the home that's owned with his ex-wife. Well,
his current wife. They've been separated for 18 months.
I'm getting someone here on text querying you, David. No, she doesn't have the right to visit. Quiet right of enjoyment, David is citing here.
Yeah, I understand the concept of the right of quiet enjoyment, but the answer would be they are both owners of a property. There is no agreement between them whereby one is excluded. So that's the catch.
Where, say, you might have that written agreement between a landlord and someone who's leasing the property where that principle applies, because there's an agreement that I'm leasing it from you, so I've got it and you've got to ask me if you want to come around and inspect things.
And there are also, on the breakup of a marriage, often orders about exclusive possession for property, and there might also be a personal safety intervention order there.
Okay. Steve in Wattle Glen, what's your query? Good morning. Steve, are you there?
Oh, sorry, yes. So about a month ago, I went and had an operation, and part of the application, if you like, to go into the hospital was if you wanted a shared or private room, and I said shared. And sure enough, about when I woke up, I'm in a private room. And now they've sent a letter of demand for the convenience of having the private room. Do I have to pay?
What does the agreement... Do you have health insurance or not?
Yes, I do.
And what does your... I mean, my view is that if your documentation says a shared room and you end up with a private room, that's a bonus.
That's how I thought it was too.
So,
yeah.
Provided the paperwork at the time of entry says shared room, I don't see you've got an issue, and I would be making a complaint to the hospital.
Very good.
Thank you.
Thank you. That's it.
Yeah, and hopefully that goes well. They don't normally do that. You normally come to an arrangement if you're in the public system, for example, and they say, would you like to go private or use a private room? Then
we're talking about two slightly different things.
Yes.
What's happened is he's gone into hospital and, in a public hospital, the allocation of private or shared rooms is dependent upon the hospital's assessment of your need. You could go into a public hospital, and that's their assessment, not yours.
Yes.
You could go into a public hospital and they would ask you, would you like to be treated as a private patient?
Right.
So they get payment from the health fund rather than just the government.
The money comes through that way.
Yep.
It's often quite a useful way to use up those resources, to be honest, and then, those beds that are used for people who don't have private insurance then. Mark in Collingwood, good morning.
Good morning, Virginia and David. I have a house that historically has had a shared driveway with the next door neighbour. The shared driveway itself hasn't been used for donkey's years because the house on each block has had air conditioning units and things like that. I now wish to put a dividing fence along the boundary line, but the neighbour doesn't want to.
Right.
Am I allowed to?
Well, I take it that, let's say there's a driveway or a pathway which is 3 metres wide, and there's 1.5 metres on your title and 1.5 metres on their title.
That's something like that, yes.
Yeah. I've often wondered about this, I must say, because there's an argument that you could be allowing them access to your property by still having a fence down the middle. But I would have thought that if I was a magistrate and asked to determine the question, you would be restricting their access to the easement. So why don't you see if you can
There's no easement. There's no easement.
So who owns the driveway?
Well, half of it is owned by them, half of it is owned by me.
So if there is a common boundary line up the middle and there are no easements of carriageway in either way, then we then come to the Fences Act, and under the Fences Act because they will have required no rights of easement of use over the property because of it's called the concept of lost modern grant, so they'll have no rights there. Your answer would be the process is to serve a fencing notice under the Fences Act. If you don't get the solution that you want or your neighbour's agreement, you go to the magistrate's court for a fencing order.
Excellent. Thank you very much. So it's called the concept of lost...
No, the lost modern grant is how you might acquire an easement.
Oh, okay.
But you won't have the right number of years. Make sure that your title and your neighbour's title don't show easements, and then use the process contained in the Fences Act. Talk to a fencer about what the fence might look like.
Fences Act. Okay.
Good luck.
Thank you very much.
Hope that's helpful. Nice to hear from you. Thank you for calling in. 1300 222 774 is the number. I'm being prompted and reminded, so let's get to this at the end, that you didn't get to finish your Italian toilet story, if there were more details to it, because I raced in with mine, just,
Yours was much better than mine.
Far too eager to tell my story, so we'll get to yours, okay? So for everyone listening at home with bated breath and finger poised over the flusher, we're going to get to David's Italian toilet story in just a moment. Lee in Geelong, you've got a question about VCAT, don't we all? Lee,
hello.
Hello.
Hi, how are you both?
Yeah, good, thanks.
David, I'm a self-represented applicant in a VCAT matter, and the respondent has failed to supply details as directed by the VCAT person.
Yes.
And I just want to know, if they haven't done what was asked of them in a direction, am I then allowed to ask for a determination for damages that I was seeking, or should I only just apply for a time extension?
Why would you apply for a time extension? Because they haven't done what they're supposed to do?
Well, because I'm self-represented, I haven't got a clue what to do.
Well, no, you've got some directions. So you've had a directions hearing, and the directions hearing says that you do something, then they do something else. Then the matter is either listed for a mediation or a hearing. Have you got a mediation coming up or just a hearing?
It is a mediation. No, look, I'll say it's a hearing from the wording.
Okay, well then what you would be doing when you got to the hearing, and you'd simply say that your problem is because you're self-represented, there's not going to be an order for costs wasted as a consequence of their failure. So depending on what the case is about and what they've provided to date, you might like to consider making an application that their response be struck out and the matter proceed undefended.
Yeah, okay.
On the basis that they haven't provided you with any material in response to your claim.
Yeah. Okay.
Right. I hope that's helpful. Thanks so much. We've got another fencing dispute. This fencing dispute's from Susie in Melbourne. Susie, what's the story?
Hi, I have a problem with a neighbour that involves a probate application and executors. It's a fence that is 45 years old, falling down or has already fallen down, is dangerous. I've gone through the entire process of notice to fence, all of that sort of thing. It's basically at a point where my only option, as far as I know, is to go to the magistrate's court and get an order to fence the property.
Yes.
My question is that as probate has been granted but not finalised, and that the executor is refusing any form of discussion, won't respond to emails, won't take any action despite having almost reached an agreement, can I actually apply to the probate court to get any level of order from them that it's a dereliction of duty as an executor?
I think the magistrate's court's going to be a lot cheaper. A lot cheaper. Is the executor registered as the owner of the property?
No, the deceased is registered as the owner of the property still.
Then I would issue... And who did you serve your fencing notice on? The executor or the deceased?
I originally served it on the resident who is a family member who was the deceased carer, who negotiated with me in bad faith. I then forwarded that to the executor.
Right, so you're going to rely upon service upon the executor, who at the time you served the order had received a grant of probate from the Supreme Court?
Correct.
Then I would issue the proceedings against the executor, who would be entitled to an indemnity from the estate for any costs incurred. So I would be going against the executor. Yep.
Okay. Great. Thank you for your help.
Go ahead, and I hope that helps and sorts things out. Sam in Tarneet has a question, and I've got to say this has happened to a few people I know and to me as well in the past. Sam, what's going on?
Okay. Hey, guys. Long story short, my brother passed away in 2005. Now, I cleared up his sort of finances and were paid out by his super in 2007. Now, my father's just gone into a retirement home. Both elderly. Look through their documents. They haven't cashed their cheques from 2007.
And who wrote the cheques?
The super. I won't know the super.
The name of the super fund. I would go back to the super fund and ask for the cheques to be reissued.
Can the super fund say? Can the super fund say no too late?
We have a concept called unclaimed monies.
Yep.
And if you were to look at I'll give you two email addresses.
Oh, yes.
The first one is sro.vic.gov.au. That's the State Revenue Office Victoria, and they look after unclaimed monies and probably will for the super fund. If it's not there, then have a look at the ASIC website, asic.gov.au, and they have a section on unclaimed monies as well, and search on your parents' names.
Yeah, because they're having a problem, because I think it's so old, they're having trouble trying to find any documentation, which I'm sure I would have got rid of.
Well, the process is this, if let's say the cheque came from me. If you hadn't banked that cheque within 12 months and I couldn't contact you, my process that I'm obliged to follow is I'm obliged to send the proceeds to the State Revenue Office, and the government mines it for a period of time, and if you don't claim soon enough, the government snaffles the money. So I would be looking at both ASIC and the State Revenue Office to find out whether there's any unclaimed monies there in your parents' names, and I would be sending copies of the cheques back to the insurance company, because it's possible, not guaranteed, but it's possible that the insurance company may have replaced those cheques at a later point.
Ah, okay. And that money may have been paid out.
May have been, but that's what you want to find out. But
okay.
15 years on, I'll let you know next week whether you're too late.
Right.
Okay.
Okay. Well, hey, thank you very much. Appreciate
Sam, can I ask how much it is?
$40,000. Yeah.
Oh, mate.
Yeah. Yeah, and they really do, because obviously they're really elderly, so retirement homes aren't cheap. So
absolutely.
They're freaking out. Yeah. So I appreciate the help. Thank you.
Sam, will you stay in touch with us? And listen in next week as well, because David will have those details for you. Notwithstanding the time gap, the super company is obliged to pay that out, right?
No. The super company's obligations are discharged by paying the unclaimed money to either ASIC or the SRO.
Sure, no, I get that. But if the money is somewhere and therefore can be picked up, that's fine.
No, the unclaimed monies legislation then goes on to say that if nobody claims it for a period of time, the money stays with the government and gets added to government revenue.
And we need to figure out if 2007 is the cut-off.
Yes.
What about another kind of cheque? So a cheque that you got from, X company, a refund for something, and you find it and it's from 2007. Are they obliged to honour that?
They follow exactly the same process as the unclaimed monies.
Right.
Now, we're at the point...
Even if it's just a small company, a little mum and dad company?
No, they're obliged by law. If nobody, if nobody presents the cheque, you're supposed to follow this unclaimed monies process.
Oh, yeah? And how many do that?
Not many. We do it every couple of years. We probably should do it more often. What happens is we have an annual audit every year, and if there are unclaimed monies, that gets picked up as part of the preparation for that.
Yes, I've gone through the Lost Super website, and that's a really good one, actually.
Oh, it's fantastic, yes.
That's a great way to find it. Okay, toilet story, go. Okay,
toilet story was a toilet was constructed after the building was constructed, and it was one of those recessed cisterns which fitted in a wall that was only 22 centimetres wide, and the cistern was was one piece of... plasterboard away from the bed head of someone's bed. So as you can imagine, it would make you would be more sensitive to it than it would be if it was on the other side of the wall and entirely within the bathroom.
It's a similar story to mine, it turns out.
Well, in this particular case, there was an action by the people who had the bed, who said this is an unreasonable and unwarranted intrusion into our privacy. It went through a whole series in court, and it was 3 decibels louder than the permitted volume for this, and the answer was the toilet has to get moved.
And so will it be?
The highest court in Italy has issued an order that it happened. One would presume so.
You really want to read this judgment in Italian. It'd be quite funny, actually.
I shall send you a copy in Italian.
Thank you so much. I would like to see that. David Whiting is back with you next Tuesday. A few follow-ups there, but don't forget to tune in and call in if you've got some issues you want dealt with.